Welcome to Illinois Law. This is a service of the Illinois State Bar Association, and I'm your host, John Theis. Today's program is going to focus in the area of divorce, and particularly in the area of planning or pre-divorce planning or planning for when you're about to go through a divorce. It's an unfortunate fact of life that over half of marriages, first marriages, end up in divorce, and people are usually not planning that and not expecting it. So we put together a distinguished panel of guests to discuss issues that people should be thinking about before they, in that process that leading up to possibly being involved in divorce. And I'd like to introduce our panel at this time. Sandra Crawford is an attorney in private practice. She is a graduate of John Marshall Law School in 1989. She is currently the chair of the Illinois State Bar Association Women in Law Committee, and she is involved with trainers for the advancement of collaborative practice, which trains attorneys, mental health, and financial professionals in the collaborative law model of conflict resolution. She's familiar in the area of mediation, arbitration, and litigation as well. Our next panelist is Julie Neubauer. Julie is a graduate of Northern Illinois University College of Law, and she currently is in private practice with Ehrenberg Goldgen in Chicago. And her practice is in the area of divorce. Obviously, that also includes child custody issues, domestic violence, orders of protection, and other issues related to that. Sandy Blake, our third panelist, is a staff attorney at Lifespan Center for Legal Services and Advocacy, which works with victims of and survivors of domestic violence. She's a former assistant state's attorney and a graduate of Loyola University Law School in 1992. And I thank you all for coming and joining us here. And you each bring a unique perspective to the discussion. I guess the first thing to talk about is nobody thinks when they're getting married that they're going to go through a divorce, but as we talked about, many marriages do end up that way. What are common things that people don't anticipate that they should be thinking about once they've made the decision or they're pretty close to making a decision to go through the divorce process? Would anyone like to jump in on that?
I'd like to start, John. I think what the public needs to know is they now have choices. They have choices in the process that they would choose for divorce. And some of the choices are they can go to court, commonly known as a litigated process, but they can also go to mediation, which is another type of process. And finally, on the spectrum of conflict resolution, they can go to collaborative process. And all those processes are different, and they all have risks and benefits. But I think clients need to know in this day and age, they do have a choice of the process that they choose, and they should be seeking out information about what best fits their goals and their family's needs and their ideals, so that while they're starting to get ready for divorce, they should seek out information about each of the different processes and the risk and benefits.
Well, Julia, how do they find out, and at what point of the process do they find which way to go, or how? I think a lot of people maybe assume that it's going to go through litigation, it's going to be a tough fight and that sort of thing. At what point in the process do they learn how best to approach their particular situation?
I think it's best to do that right from the very beginning, to start educating yourself as to not only the various options that are out there for how you want to proceed, and also, if the opportunity arises, to talk about that with your spouse. If you're going to choose a collaborative process, it is definitely something that has to be agreed upon between both parties so that both of you are on the same page. And if you're not necessarily in a place with your spouse where you can talk those things through from the beginning, starting out by retaining a private practice attorney might be the best way to go, and options then can unfold throughout the divorce process that will allow maybe a more cooperative approach if available. And if cooperative approaches are not the result for your particular situation, or if you feel that it's unsafe to do so, there are always litigation measures that are available to parties. But what's really most important when you're going into that divorce process is to start asking yourself the questions, what do I want when my marriage is over. So many people just start out in an emotional place where they just want out of their relationship and aren't necessarily thinking through issues of financial matters, issues related to the children, and how they want to proceed when they no longer are a one household family any longer.
Sandy, maybe you could answer this. Is it inevitable that a divorce situation is going to end up being contentious and is going to be difficult for everyone? Or are there ways to make it easier if this is something that both parties have come to the conclusion that the marriage is over and they just want a way out of it? Are there ways that they can be walked through that make it easier for everybody?
I think there are ways, and I think that when you set out with a client, now the vast majority of my clients, well, my clients are all victims and survivors of domestic violence. And the vast majority of them are, although we do recognize that men can be and are victims of domestic violence, the vast majority are women. However, and they're not necessarily starting from a level playing field. Domestic violence is not so much an issue of anger as an issue of power and control, so that one spouse exhibits and manipulates the other spouse into a position of subservience and minimizes that spouse's position in a family, contribution to the household, and things like that. What we work with our clients on is we have a threefold focus. One is focusing first on her safety, 2 on the perpetrator's accountability, and 3 on resolving the issues, and she is accountable. It's all her choice. So what we do with our clients is we sit down and we find out what they want. What is it that how do you see yourself and your marriage, or your family, once we finish the process?
So even in a situation where it comes to the attention of your organization where there has been some sort of domestic violence or domestic abuse, even within that, the situation can be brought to a point where both sides can move forward from that?
I believe so. The vast majority of mine, I work with a lot of pro se respondents, the husbands.
By pro se, you mean
non-represented.
These are individuals representing themselves. They don't have a lawyer speaking for them or stepping up for them in the process.
I would say about half of my cases, the husband, again, represents himself. Although I do have a couple of male clients, but the opposing party is representing him or herself, and we do actually try to work out agreements based on what they both, negotiate. Even though there is the issue of domestic violence, the vast majority of cases, they have children together, and they're going to be dealing with each other for the next 18 to 23 years.
Right. Well, one of the things when we spoke at the beginning as to what we're trying to look at here is what kind of things do people not anticipate and not think about where you're in the middle of the divorce process and you say to yourself, boy, I wish I had anticipated this. And what would you tell someone, any of you, what would you tell someone?
If I may, I'd like to jump in here.
Sure.
One thing that I tend to tell clients right from the very beginning is that if you're looking for justice, don't come to divorce court. Divorce court is not the place to find your vindication, to stand up before the court and all of your peers to share your story. Most of the time, your story is not going to be told in a public forum. Divorce court is a venue to dissolve a marriage. The purpose of it is not to punish one party and vindicate another. It is to end a marriage. So I urge all people who are contemplating divorce and are in the emotional throes of the end of a relationship that is oftentimes pivotal and most important in their lives up to this point, to really come to a place where you are truly done with that individual that you are married to before you embark on the litigation process. Because too often people are searching for that opportunity in the court to feel justified, to feel some sort of benefit that really is not going to be available. The purpose of divorce court is to allow a marriage to dissolve, to create two separate households again, and to help the parties find a fair and equitable result in terms of support, property division, and managing the children if there are minor children involved. So issues of emotion kind of get in the way sometimes.
And that's something that you've all seen that people don't anticipate, is that right? That they want that opportunity to vent about the last 10 years of the marriage?
I think people from watching maybe popular TV and popular TV shows maybe have a skewed idea of how a process unfolds. But just statistics here in Cook County, an average litigated divorce can last 18 to 24 months. And if you think of the toll on children in that process, it's very difficult. So I think what the public needs to know is, the divorce continuum, the spectrum is, on any given day, the law is probably about 25% of what we're going to be dealing with. The other 75% is the emotions and the finances. And I think in terms of getting prepared, knowing your finances, doing a budget, understanding your assets, understanding possibly what you don't have is important.
Well, after the break, I'd like to talk about some of the alternatives then, since it won't be litigated necessarily in the courts. I want to see how this, maybe explain how some of these mediation other processes work. This is Illinois Law. This is a service of the Illinois State Bar Association, and I'm John Theis, your host.
Bye-bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault! Never! Mister!
Over and over.
Time I come home! It's our problem! Leave me alone! Shut up! Out!
Time and again.
No! Drive me nuts! Shut up! You're the dumbest...
Generation after generation.
I hate you! I hate you too!
Isn't it time you stop the cycle? Now.
I hate you! I hate you!
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to Illinois Law, a service of the Illinois State Bar Association. I'm your host, John Theis, and we're here with a panel of guests talking about divorce and specifically pre-divorce planning. And we have a panel of guests here, Sandra Crawford, Julie Neubauer, and Sandy Blake. Before the break, we started talking about things that people don't ordinarily think about. And Julie, we talked about some of them. What else do you think people don't necessarily anticipate that they should be thinking about?
Well, in most counties in Illinois, there is a requirement of the court to complete some form of a financial affidavit, which encompasses your income, your household, personal, transportation, and child-related expenses, and a consensus of your assets as are known to you from the very beginning. In Cook County especially, you cannot embark on what is known as the discovery process, which is essentially gathering information from both sides to accumulate for both parties to know what the big picture of their financial situation is. You can't start that process until you complete that financial affidavit. So for someone who's thinking about embarking on the divorce process, it's a good idea to get your papers in order. You want to be able to find your income tax returns if they're available to you. Know if you filed a joint or separate return for the last 3 years at least. Find your pay stubs. Look for your credit card statements for at least 6 to 12 months going back. And try to find your car title. See if you can find all of the papers, whether or not you are organized at home. It's best to gather the information so that you can complete that affidavit as accurately as possible, because it becomes one of the most important tools to allow the court or allow the parties to really see what an equitable and fair division of assets would be, and also to make a good determination as to support when that is an issue in the case.
Julie's talking specifically about issues that apply to any divorce situation. Sandy, you've been involved for years in the area of domestic violence and domestic abuse. Are there things that are unique to those type of situations that there's some problems in there that people should be thinking about, and alternatives to what they're involved with so that they can get out of those situations?
There are. In fact, I was actually reading something, and I guess I should have known this for a while, but FBI reports indicate that the average victim of domestic violence leaves her abusive situation 6 to 12 times before she leaves it completely. There's a lot of separation and reconciliation a number of times before she leaves for good. In that process, the woman, again, I'm using the generic female because the vast majority of our clients are female, but each time she works on what we would call a safety plan. She needs to know the kinds of documents she needs to survive on her own. A lot of times they don't know what their husband does for a living. They don't know where he works. They don't know if her name is on the title or bank accounts. She has no idea how much income he's got. She needs to gather that information. She also needs to gather, for example, birth certificates, marriage certificates, school records for the kids, medical records for the kids, so that when she leaves, I had one of the biggest benefits of our organization is that we also provide counseling services. And I was talking to our director of counseling the other day, who also teaches, and she said she did an exercise with her class the other night, and she said, she painted a picture, and imagine it's 10:30 on a Friday night. It's raining. You have no transportation. You've got 3 children, and you've decided that you've got to leave. What are you going to take? What are you going to walk out of your marital home with and still survive, because you can't take it anymore? And it's pretty much what you can carry and what you can wear. So, what is it you're going to walk out of there with? You're going to need the documents. You're going to need some clothes, a phone.
And your organization, which focuses in this area, is called what?
Lifespan.
And what is their mission?
We're a nonprofit organization, and we work with victims and survivors of domestic violence. We do counseling and advocacy. We work with counseling for the survivors and the children. We do legal services, child support, paternity, orders of protection, and divorce for the women and men. I do, like I said, have a male client. Right. And we also do work in grade schools and high schools for preventing teen violence.
Okay. Well, obviously, the domestic violence and domestic abuse situations are the ones that where things are pretty far along in the process. But in any kind of a divorce situation, there isn't always, of course, violence involved. We did talk earlier about mediation. How does that work? How does a mediation process work, Sandy?
Well, in Cook County, if you're in the court system, at least here in the state of Illinois, if there is an issue with respect to the children, and we have to remember they're kind of the unspoken voice a lot of the times in a divorce process. The adults are getting to speak, the children need to have a voice. But in most circuits, there is a referral to mediation if custody is going to be an issue. If the parents cannot agree, they will be mandated to attend mediation. But mediation is a voluntary process. They can be sent there, but they can't be made to make an agreement. And the hope is, with mediation, with a neutral third party who's trained to facilitate conversation, to facilitate problem solving, that the parties by themselves, the parents by themselves, will come up with a plan. Because if they create the plan, statistics and research have shown that those plans are more sustainable than a plan that's held, given to them by a third-party decision maker, such as a judge or after an evaluation, because the children do need to be tended to. Their needs, their scheduling does need to be tended to.
Is mediation more common then in the area of child custody and child issues?
It is, and it's mediation has been around for a long time. Mediation is probably a 30-year process.
But the process then by which this happens, the parties are already in court. Is that right?
Sometimes, not always.
Okay,
Most.
so we hear people talk about contested, not contested divorce. Maybe one of you could explain what does it mean to have a contested or not contested divorce?
Sure, I'd be happy to. Essentially, contested really means whether or not all issues between the parties have been resolved. They can be everything from the basic grounds of divorce, if you are contesting whether or not you are irreconcilably different to the point where you can no longer resolve your marriage, to issues of children.
So one party might not agree to that. One party might say, no, I think we can still...
It is technically possible, yes. You don't see that very often, and I will be very honest, that rarely ever happens, and most times it's not even entertained by the court. However, the issues that really do keep people in a more litigious format or an unresolved format of divorce surround children, financial, and support most of the time. Division of marital assets is often a difficult thing to manage when it's complicated in a financial matter. However, the children matters and issues do take most of the court's time, I think, in terms of trial. When a matter is uncontested, the parties will sign their marital settlement agreement and a custody judgment along with a joint parenting agreement, bring it to a court, and have what's called a prove-up. The prove-up is where you go before the court and the court makes a determination based off of testimony of the petitioner and the respondent that grounds have been met, jurisdictional requirements are met, and that the agreements made between the parties are fair and equitable. If the matter is contested, any portion of it can be brought to trial. You can have a trial.
Including custody issues or financial issues or what other kind of issues might be contested?
It's usually custody, parenting time, child support, maintenance, or division of marital assets. And in regards to asset division, there's also characterization and valuation that are often up for dispute. Now, in any given situation, you don't have to go to trial on everything. Sometimes people do. Other times you go into a trial situation with certain things called stipulations, where you have resolved some matters, but some are still up for decision.
So we've agreed on A, B, and C, but we disagree on D, E, and F.
Correct.
And we're just leaving it up to the judge to decide that.
Right, and when you do that, you end up in a trial scenario where testimony is taken, and experts are often involved, and it becomes much more expensive most of the time when you go to trial. A contested case will always be more expensive than an uncontested case. However, there are many cases that end up in the end technically uncontested that took a long time to get there because it took a long time for the parties to come to resolution.
Are there ways that people who practice in this area, lawyers who practice in this area, are there ways that are traditionally helpful in making people see that the best way to do this is not to have a full litigation? And well, how do you convince someone for the sake of the children and for the dwindling marital assets not to be
I sometimes send them on a field trip to the courthouse. Because I do various forms of process, litigation, mediation, collaboration. When my client comes into my office, I give them those choices, and then I'm fortunate that I'm right across from the courthouse, and I say if they want to choose litigation, go on a field trip, sit in any one of the courtrooms, and come back and tell me what you think of that process and how you would like your case resolved that way, because litigation can be oftentimes long, costly, and can do more damage to the relationship than when they started off. I mean, they start off in a very bad place. The time and the money spent and the contentiousness can leave them in a worse place than they started off with. And if they have children, they may have years and years in that parenting relationship. So you tell people, you're going to divorce one another, but you will never divorce your children. You will always be parents in relationship to those children, and you need to preserve that if you can. You know, even if there is issues of violence, you need to have some assistance maybe, and it's maybe not legal assistance, it's mental health assistance or financial assistance, especially in this economy where properties have been devalued and you're fighting over a smaller pie.
Right.
You may need some expert advice, not you know, dueling experts, but advice that both of you can work a solution around.
And the reality is that the attorney's fees are going to come out of those marital assets one way or another, and often when there's attorneys on both sides, that they were that's going to that dwindling pie will get even smaller.
The practicality of cost really does become a motivator for people to resolve their issues. It's easy to act on principle when you don't have to pay for it, but when you're faced with the reality of doing so, you can find a way to compromise so that your agreements do work in the end anyway.
And you've seen that as a motivator, that people might come into it ready to go to the mattresses, but then when they find out what it's going to cost them,
it happens.
Yes.
And even if it's not a financial cost, again, my clients don't come at it from a level playing field, but I frequently tell them, look, you know, if you can work something out together, what is it you want? What are you willing to live with? And any agreement that you come to together is something that you are likely to live with or be able to live with. If you let the third party decide, it's something that neither one of you likes.
Most of the time, that's the truth.
Well, this has been very helpful for me, and I hope people learned something about things that they should be thinking about as they get ready to go through the unfortunate and difficult situation of divorce. And I want to thank our distinguished and a very helpful panel, Sandra Crawford, Julie Neubauer, and Sandy Blake. Thank you very much for joining us.
Thank you.
Thank you.
This is Illinois Law, a service of the Illinois State Bar Association, and I'm your host, John Theis. Thank you very much for joining us.